Good morning, all. Just waiting on a few more people to arrive. As I say, if you are joining us, if you can keep your microphones muted, and also if you can just turn off your cameras if you're not one of the panelists, and we'll make a start shortly.
I will do. Thank you.
Good morning and welcome to this mock dispute resolution webinar. Thank you for joining us. I see we've got a good crowd of people from various parts of the world. Welcome to those who are joining us from somewhere further afield. In terms of housekeeping, just before we start, as I say, if you can mute your microphones if you're not speaking, that'll avoid any background noise. If you can also turn off your video, just to make sure we save on the bandwidth and we can have a strong connection. As we go through the webinar today, there'll be an opportunity for you to ask any questions, pass any comments via the chat function. If you have any particularly pertinent questions you'd like to raise, then you can raise your hands virtually as we go through the session. And what we'll try and do is save most of the questions towards the end if we can. We've got a couple of scenarios to run through. That is going to take us probably 2/3, 3/4 of the time, and then we'll have some time for questions at the end. So if you can, please mute your microphones. If you're not speaking, that'll be appreciated. In terms of the agenda for today, we're going to do some introductions shortly. We'll give some background to the fictional project that we're going to show some options in relation to dispute resolution in relation to. We're going to run through dispute resolution using more traditional approaches and how that can cause problems and may not be as good as using more proactive measures. And then we're going to rerun the same scenario, looking to use the processes within the NEC4. And we're looking primarily here at the ECCD engineering and construction contract to try and look how we can use the tools within that more effectively. Those tools are present in the other contracts in the NEC suite, but we'll use the ECC as a basis. And as I've said, we'll have some time at the end for questions. So start with some brief introductions. So my name is Ian Heaphy. I'm a member of the NEC4 contract board and one of the NEC's teams of consultants. Today, I'm going to be representing the subcontractor as we go through the mock scenarios, and also changing hats and acting as the senior representative of the contractor when we get into issue resolution later in the case study. Matthew?
Yeah, good morning. Matthew Garratt. I work for Costain. I'm also an NEC4 board member, and in this session I'll be representing the contractor.
Nisha?
Hi, good morning, everybody. I'm Nisha Desai, Operations Director at Mace, and I am going to be playing the project manager today.
Thank you. Julie?
Hi, I'm Julie Forsyth. I'm a partner at law firm Gunnar Cook in London, an arbitrator and adjudicator. I'm going to be playing the adjudicator and the client senior rep.
And Mark?
Good morning, everyone. Last but not least, I'm Mark Doherty, Commercial and Contract Manager for Yorkshire Water Services, and in this webinar today I'll be playing the client.
Okay, so Mark, can you take us through the background to the project?
Yep, so I'll just quickly introduce the project. I'll try not to use too much time on it. And if you're on the early warning webinar last year, you'll see most of this is quite familiar. We've used the same overall project. So it's the construction of a new hospital on a site next to an existing hospital. And I've engaged various members of the team, and I'll show it on the next slide. But the main thing to look at here is that the dispute resolution in all of the different contracts is W2. So you can see I've engaged my designer on a professional services contract, option A. I've got an in-house agreement with my project manager. The main works, so the main contract is on an ECC, engineering and construction contract, option C. So that's your target cost with pay and gain. And they've in turn engaged our subcontractor for today, Rockshore Piling, and that's on an engineering construction subcontract, and that's an option B, so that's the bill of quantities. So in terms of background, the work's commenced on site and the subcontractor starts construction. The work is programmed to start in week 3, so that's 2 weeks after the starting day, allowing for 2 weeks of site setup, and to take 10 weeks. The work is on the critical path, as you'd imagine, for piling works, and it's a fairly linear activity where we expect around 10% of the piles to be installed each week. So once the piles are 90% installed, we then expect that the capping beam can be commenced, and that's programmed to start 9 weeks after the piling. So that's week 12, and to take 8 weeks to complete. And as you can see from the previous organogram, the design is coming from the client's designer. So as you can see there, just a simple illustration of what would be the clause 31 baseline program, showing the starting date, 2 weeks site setup, 10 weeks of piled foundation, and 8 weeks for the capping beam. So in terms of what actually happened, the piling work started as planned, but the subcontractors run into a problem during installation. That's partly down to the complexity of the design, and after 2 weeks, the piling works are only 8% complete against an expected 20%. The subcontractor, when reviewing his design, has seen that the capping beam does have an error in it. So due to that complexity, there was a hidden error in the design. So the contractor calls for a meeting with the subcontractor to discuss progress on that design error. So I suppose just quickly in the chat at this point, sorry, I've got my cat on my keyboard. What should the contractor do from your own perspective and in your own experience? I suppose with those, we'll just let those answers come in, and then Ian, do you want to come back to those later in the session?
Thank you, Mark. Yeah, I think some answers are coming in, all seem pretty consistent and seem very sensible. So let's now look what happens in our mock scenario. Do things happen as they should? So, contractor Matthew.
Right, okay. Now, we've got a bit of a problem here. Progress is slipping, costs are going up. I need a solution.
Well, I've got to say, I'm the subby doing the work out there, and it's tough. The design is way overcomplicated. Designer hasn't got a clue what they're doing. Project manager, nowhere to be seen. It's a nightmare. I'm getting no help. It's all going horribly wrong. But in fairness, this is going bad and we are going to be delayed, but there's an issue with their design. I've spotted an error in the capping beam design. So they're going to have to change the scope to correct that. So that may be our saving grace. We may have a way to try and hide our delays here if we wait for that change in scope to come out.
Yeah, we don't want our own delays to cause a problem now, do we? The costs are going up. We can't afford any more costs of our own. We've got to recover this. We've got to come up with a solution. Yeah, lay low on the moment with our own delays. We can't highlight all that. I'm still convinced we can recover this.
Yeah, okay, I can do what I can. I'm going to put some extra resources on. I think we can pull some of it back, but as I say, I think there's that change to the scope coming that's going to get us out of jail here. So let's get our heads down. Let's just tell everyone everything's going to be okay. We're going to pull it back. We're going to be back on time, and let's see where we go from here. Yeah,
let's focus on that design change that's coming and see how we get on. Meanwhile, you've just got to recover that delay. Do whatever you can.
Okay, I'll do it.
Okay, so the contractor submits an updated programme for acceptance that shows the piling works completing as planned and the capping beam works also commencing as planned. Shortly after that submission, the client's designer spots the design problem and informs the client and the project manager. The project manager and the client then get together to discuss the situation themselves.
Hi, I think we've got a few things we need to discuss. I don't know if you've seen that programme that's just come in from the contractor. I mean, it is an absolute joke.
Yeah, it doesn't really reflect what they're doing on the ground, does it?
No, I mean, obviously they're showing they're going to be late. I mean, which is the first we've heard of it. I mean, they're obviously well behind on their piling. I mean, I don't know whether they were just being optimistic or they just don't know how to do basic planning anymore. It's just not very clear. So we're obviously going to reject it. There's just no way that we can accept a program like that. So I will speak to them about that.
Yeah, definitely. I think we've got to reject this one, but maybe we need to just talk to them first, understand how they think they're going to pull it back.
Yeah, I'll have a chat to them, but I'll tell them that, this program is just, obviously a load of rubbish. But we have got another issue. There is a bit of a problem with the design. So our designer has come back and said we've got some there's an issue on the capping beam design. So that's going to there'll be a bit of delay with that. We'll have to issue an instruction, but it's going to be nothing in relation to the delay that they're also showing. So I think it'll be fine. It'll get subsumed within that. So let's see what they I think we just hold on to that for now and sort out what we've got to do by the time we figured it out. Let's see. I don't think it's going to slow them down in any way.
All right, that's great. Let's just keep it under our hats then.
Yeah, I'll keep it to myself for now. Okay, so the designer does end up redesigning the capping beam, and the project manager issues a change in scope to reflect the revised design, also notifies the event as a compensation event, and instructs the contractor to submit a quotation. So that's all been done at this point. So contractor comes back, submits their quotation, shows that there's going to be a delay of 6 weeks, which is entirely due to this issue with the change of the design, and obviously impacts the completion dates. They've also assessed the change at 200k, which based on their assessment of the costs. So that just shows it in terms of the time. So it's just showing all of the delay within that compensation event, rather than what they were already forecasting as previous issues. Okay, so I think we need to discuss this compensation event quotation that you've sent.
Yes. Okay. Yeah. Be more than happy. Are we ready to agree it?
Yeah, no, I don't think we're ready to agree it. I mean, I'm really surprised that this is the program that you've submitted, and your compensation event. I mean, I just didn't know what to think, really. I mean, I haven't heard about any of these issues before. I'm just really disappointed, to be honest, and I think I'm just obviously going to have to assess this myself, because we're completely worlds apart on how we see the situation.
Well, I don't know what you mean. We've got Rockshore Piling involved here. They are absolutely the best in their field. There's no way we're finishing that piling late. I'm absolutely confident. I've had it promised. He promised me this morning he's got a solution. So, that's why we didn't raise an early warning, because we're bang on track.
I mean, there's absolutely no way you're bang on track. I can't see how you're going to get this back on track. You're not being realistic. I don't know how I'm supposed to manage this project if you're not going to be realistic. I mean, how are we supposed to move forward with this? I mean, I think I'm just going to do my own assessment. And then, I think you're just trying to take advantage of this situation because we've issued this change. So I will just do a project manager's assessment of this CE, I think.
Oh, this is a nightmare. It feels like you're just trying to stitch us up. We're already losing money,
Well, I mean, that's for you to manage, really, isn't it? So.
Okay, let's move on.
Fine. Okay. So the project manager doesn't accept the quotation. They believe the start to the capping beams would have already been delayed to the same point in time due to the delay in the installation of the piles. So there is the issue around the failure of of notifying an early warning, and then the project manager obviously decides to issue their own assessment of the quotation, which states there is no change to the completion date. The project manager also ignores the contractor's assessment of the direct costs and only values this at 75k as opposed to the 200k that's been submitted. Okay, so obviously contractor is not happy with this quotation and how it's been reviewed, tries to get the project manager to discuss with the client and take another look, but they are absolutely saying no, this is their position now, they're not going to move with it. So the contractor instigates it as a dispute and doesn't take up the option to take it to the senior representatives as it could have done under W2, but instead starts an adjudication.
So on the adjudication, we're not going to go through a role play so much, but I'm just going to highlight for you a couple of things that I think you need to bear in mind if you're thinking of starting an adjudication in this way. As most of you all know, it was introduced, statutory adjudication in the construction industry introduced a while back, 1996, on the Construction Act. Or the Housing Grants, Construction and Regeneration Act. It applies if you've got a construction contract, and it gives you a 28-day procedure. So although you can have, and often people do try and extend this, it's meant to be a short, sharp fix, a pay first and argue later scenario, just to keep projects moving, which was a great idea originally. But as we all know, I think it's moved into something completely different now, where you can end up spending a lot of time and a lot of money and not necessarily get a better result than if you just sorted it out beforehand together. It's a formal claim. It's akin to litigation. It's prior to litigation, but it's once you get into it, you're in it. People have spent money on their lawyers. Some people will bring in barristers, will really throw everything at it. So once that money is invested into this dispute, it's very hard to dig yourself back out of it. You're going to have to pay for your own legal fees. That's embedded in the statutory requirements that you cannot agree not to pay your own fees. So even if you win 100%, you're still paying for all the money you've invested in that. There's been numerous cases where people have tried all sorts of ways to get around that, and as far as I'm aware, no one's achieved it yet. You're paying half of the adjudicator's fees, but remember also that you're responsible jointly and severally for those fees. So if they're not paid by the other party, you're still liable for the whole lot. So it can be very, very expensive, and not always, although it can be useful in right places, it's not something you should jump into without thinking. So it goes to the adjudicator. Me as the adjudicator, what are you going to think when the documents come in? First of all, it's very unlikely I'm going to want to have a hearing. So you're not going to have an in-person hearing most of the time. You're not going to have that opportunity which you have if you'd had early warning notices and meetings and discussions to try and resolve it. It's gone too far by this stage. You've thrown yourself into the ditch and you've got to keep with it. All your information has to be in your documentation and your pleadings, your statements of case, your response that you're putting in. The adjudicator reads that. You won't have the time to use your charm and your eloquence to stand up, bring in your experts, bring in people and explain why you were so hard done by and why this isn't fair. It's got to be put out in writing. The adjudicator will consider usually whether it looks as if there's been attempts or whether you've just thrown it into an adjudication in a bullying, aggressive tactic to just get your money. So all of that's going to be taken account in black and white. He'll also look, he or she, I should say, will also look at the contract terms. It's often a lawyer that's involved or a QS. And if it's not a lawyer, it's going to be someone from the industry who is legally trained to look at the contract. So although they'll take into account what's happened on site, they are going to be looking at whether you've complied with the contract and what the rights are under that. It becomes much less personal, much less emotional, which can be a good thing, but often it just means that you're not going to get the result you hoped for. You've also got to remember the long-term consequences of the fact that you're losing that good relationship or potentially good relationship with the people you're working with, the other companies that you work with, not just on this project, but on future projects. And as we know, the construction industry, you don't want to make enemies. It's a small world. So think very carefully before you do that. NEC contracts are designed, as you know, to encourage and support collaboration. And that adjudicator is going to think, why have you entered this contract and not used the tools? Have you used those tools? Were you attempting to cover up your delays or poor workmanship, or were you wrongfully withholding the money? That's going to be something that's considered when it gets to adjudication. So it's better to use the tools you have before you get there. So what happened when the adjudicator, are we on to the slide, sorry. When the adjudicator went in, are we on the right slide? Sorry, let me just pull it up. He decided, I've lost my slides. He decided that, yep, one party wants 200, one party wants 75. It's not surprising that the assessment went to 110,000 for the contractor delay. We've been through the delays that you had. It was assessed by the adjudicator. He looked at all the black and white pleadings. He decided that the change to prices was 90k in direct costs and 2 weeks delay at 10,000. He took into account that there was a delay by the contractor first, fell sort of halfway between the two stalls. So not such an unusual decision, but it means that you've then had to you have to take into account. Sorry, now I'm just jumping around on the slide. So you then have to take into account the fact that the parties have expended 100,000 each on the dispute, which they have to pay for themselves, their own costs, and the fees including the fees of the adjudicator, and the contractor is recovering 10,000, and it's costing the client 220 overall. So it will be interesting to see in a little while what happens, what's the benefit if you don't go to adjudication. What have those extra costs cost you in the long run? So next slide is just the, sorry, we're on the next slide. Done the next slide, yep. So who do you think, in the terms of, for the audience, who has won that? Is the contractor a winner? Is the client a winner? Or is nobody a winner? I'm just looking at the answers as they come in. I think the majority have come in. There's a few contractors in there, mainly nobody. I'm thinking, which I think it's a fair assessment that there isn't a winner. And I think with any sort of formal litigation process, formal dispute resolution process, there's always going to be somebody that feels hard done by. And often in my experience, you find that both parties feel hard done by. So think carefully before you jump feet first into it.
So lessons learned from that scenario role play. We think really between the client, project manager and the contractor, there are no real out winners. A lot of money's been spent. The contractor's not really got the recovery it needs. The client spent way more than it was due to be paid if it was resolved amicably. And I think a few people said on the chat, we identified that things started to go wrong quite early in the process when the parties stopped being open and transparent with each other and stopped following the contract. And at that point, I think they started to dig themselves into trenches that they found hard to get out of. Those bad behaviours led to further problems. And as we've said, the parties lost the opportunity really to resolve the issue themselves. And there'll be most likely some quite significant relationship damage been done by the lack of trust that's shown between the parties, probably. Okay, next slide. Now we're going to rewind the clock and look at how the issue could have been dealt with using any for dispute mitigation and resolution processes. So we're going to rerun, hopefully with some better behaviours and a closer following of the contract. So we're back to the same scenario. The piling work started, the subcontractors run into problems. After 2 weeks, they're only 80% complete, and the contractor has the meeting with the subcontractor to discuss progress and the design issue. So I've got my subcontractor. Okay, so progress is slipping, costs are going up. We need a solution.
Yeah, as I say, this design is so complicated. It's a real struggle. You know, I got my best people on it. We're really struggling, and yeah, we're having a bit of a nightmare trying to deliver the work and to hit the productivity. So I think maybe we should be looking at raising an early warning. I think we need to be sharing this problem because I think it's going to cause delay, and we could probably do with some help from the design team to understand the design. Maybe they can simplify it. So should I draft up an early warning notice?
Yeah, I think so. It will make everybody aware we've got a problem. However, experience does tell me if we try and cover this up and not follow a contract, it could really backfire and there could be a lot of damage done. So yeah, let's do an early warning. I think talking this through with others can only help.
Okay, and just you want to be aware as well, we've been looking through the design and we think we've spotted an error in the capping beam. That I think there's going to be a need for a redesign on that. Now, we could possibly just keep quiet on that and not highlight it, because that will become a compensation, because there's going to be a change in scope necessary, I think, further down the line. But I don't know, what do you think? Think we should let them know, or again, just keep that one quiet?
No, I think we should. Look, let's raise an early warning for them both, get it all on the table. Let's see what we can do. We might be able to resolve some of this. I'll call a meeting to discuss them both.
Okay. So contractor notifies the early warning. Early warning meeting is held, attended by the project manager, contractor, client, subcontractor and designer. It's a much more positive meeting now, given what's happening in the situation. There's an agreement that the designer is going to help the subcontractor to try to simplify the design, possibly even change the scope to make it easier to construct, though obviously not to any detriment of the client's long-term asset being created. So we start to work together, we start to mitigate the delays, we identify the issue with the capping being design problem. That's also being resolved through the early warning process. Actions are being taken now to work together collaboratively to try and limit the delay caused by the redesign, trying to work together to mitigate that as well as the delays caused. Redesign is finished. It's issued by the project manager, who instructs a change to the scope. Project manager also notifies the event as a compensation event and instructs the contractor to submit a quotation.
I'll take this one. The contractor submits a quotation stating that the start to the capping beam works will be delayed by 6 weeks due to the change in scope. However, 2 weeks of this is subsumed by their own delay, which we're showing now in the programme. And so the impact on plan completion and the completion date is 4 weeks due to the compensation event. We also assess the change to the prices at £150,000 based on a forecast of defined costs, which includes additional site running costs for a 4-week period of £50,000 a week, and direct costs of the, a 4-week period of £50,000 and direct costs of the additional works at £100,000. So this is a meeting between the project manager and the contractor to discuss the quotation.
Okay. Hi, Matt. Thanks for arranging this meeting. How are you?
Yeah, pretty good, thanks. Pretty good.
Great. Thanks for getting this quote. I know you worked late, and it was a bit of a fiddly one to pull together. So thanks for getting that one in on late on. I saw you submitted it late on a Friday. So
no problem. Did were you happy with it? Can we get it agreed?
So I think we've still got a few things we just need to look at. I think it's great we've now got everything in there, everything's out on the table, and I think those early warning meetings help to iron out some of those issues with the design. So still a few areas where I think we just need to either have a look at in more detail. I mean, I've been through it with Sarah, our commercial manager. We are struggling to see how you've come up with the 4 weeks. We've been through it a few times now, so we've got a slightly different view. But I think there is some stuff that we can agree in there. So some of the direct costs and some of the other items in there. So we can send you a breakdown of that. But I think just in terms of the time, we are struggling because we've got a slightly different assessment.
It sounds like your assessment's going to be a bit lower than ours, doesn't it? That could be a problem. But listen. I send it
I
through.
think you've shown the delay, and there obviously is a delay there, and I think we can all see that, we can all agree to that. But whether that's 4 weeks or whether, I think we're more aligned to it being more like 2 weeks. But obviously there is that difference there, and appreciate that is we don't want you to be out of pocket. We want to make sure that we have captured anything. So if there's anything we haven't understood correctly, we can have a look at that again. But I think we just need to move forward with this now. So we just need to sort of agree that there is another step to this process now.
Yeah, we can't accept reimbursement for just 2 weeks. There's a 6-week problem here. So listen, anyway, I understand. I'll have a look at the detail, and let's have a look, and we'll see where we go.
Okay. Well, I think if we can't if we can't get this resolved between us, we do need to just crack on now, because time is ticking away. So we've assessed it at 90k of the direct costs, and then let's see if we can get our senior representatives to look at this in more detail.
Yeah, I think that's a good idea, actually. I think that's a good idea. Okay, we'll do that.
Yeah. Okay.
Okay, so to try to keep the relationships going, to try to make sure we can move on, this is now going to be referred to the senior representatives of the client and contractor. So I'm going to sit down from the contractor's perspective and act as the senior rep, and I have Julie across the table on the client side. Okay, so what do? The team have given us an issue to try to look at here. They're working pretty well on the ground. A lot of things are getting agreed, but they can't see eye to eye on this one. Matthew's saying to me, we should be entitled to 4 weeks. So, I think we should try and see how we can resolve this in the best way, but we're still pretty keen for that 4-week delay coming our way.
Yeah, no, I can see that, but we really want to get this resolved. There's no advantage in anybody in not sorting this out between us, and I'm hoping that us sitting down like this is going to be the way to get it done. I mean, it's really good. It'd be good. We need to show leadership here. We can't leave it to the teams on site. Clearly, they're very closely connected, and it's hard for them to step back and look at the real picture. So I think it's good for us to be doing this now.
Yeah, I think you're right. I think, the teams are working well. They're following the contract. They're notifying early warnings. It's all very positive. If we can't agree and we end up in a formal dispute, I think that's just going to cause problems. So we need to look at a way of trying to get this agreed between us. But, I think we're still a little bit at odds here. So, I don't know what we could do to try and see how to, broker a solution here.
Well, I think, some of the teams, from what I've seen on site, I'm quite impressed actually at how everybody's working. They all understand the provisions of the contract, as you say. They've been using all these tools that we have in the contract to try and resolve this, and seem to have gone to the best, the extent of they can. And clearly, we as senior reps, we're not involved in the contract and in the project itself, because that's part of the joy of the whole point of it. The only thing that means is that we haven't got that close connection with the works. And to be honest, I don't know. I'm not in a position to sit down and work out how many weeks is really due. I've not been closely connected enough with it. So I'm wondering if there's a way around that we can maybe get some help on that.
Yeah, that may well be the way forward because, if we start digging into detail ourselves, we'll probably end up, you and I, coming to the same position the teams did, because they must have genuine, a genuinely held belief of what that delay is. So maybe we should get some sort of expert in, maybe an independent expert. There's probably a few people I've used in the past I could suggest, and maybe you've got some names we can share, and maybe get somebody in, independent, fresh, can look at it from that dispassionate view and give us a view. What do you think?
Absolutely. Let's put a list together and see if we can agree somebody. I'm sure we've got some people that we both think we can agree on, who'll have the right qualifications to look into this, and we can get. It shouldn't be too long a job or too expensive either. I think we can find someone that can look at this on the information we have. Yeah,
sounds like a plan. If we can get someone that we both, respect the views of, then I think we can both agree that we're going to follow their decision. And obviously, unless it's a crazy decision, as long as it's a reasoned decision, somebody we both are happy to trust the view of, let's get them on board. Let's get them to give us a view on what they think the outcome is.
Yeah, absolutely.
So we skip forward in time. An independent expert's been jointly appointed. They've had a look at the information. They've come back and recommended the quantum 90k. A rate of delay has sort of been determined, albeit it is based on the actual costs to be incurred. And the recommendation from the expert is there's a 3-week delay. So not the 4 weeks that the contractor wanted, not the 2 weeks the project manager was anticipating, but they're suggesting 3 weeks. So, Julie, what do you think to that? Are we happy to agree on that basis?
I think, yeah. I mean, it's not what either party wanted. It's fair. I think we have to go with him. There's no point in getting in an expert to assess all the information. We don't know any better than him in terms of what he's looked at. So we have to, if you're going to appoint an expert, you've got to go with it, as you said. So I think we have to agree that.
Yeah, I mean, we could, again, agree to disagree. We could then go into the adjudication process, but that's just another independent third party. It's probably going to be more expensive and we're going to incur costs from either side. So I can't see why we just don't agree with this, shake hands and move on.
I think it's not the result that he's given us is in the ballpark of what we were looking at anyhow. It's not as though it's extremely different from what we've looked at. And he's given us a reasoned decision, which I've looked through, and I can't argue with any of what he said, to be fair. So I think, yeah, for me, I'd much rather than get on with this job, keep our good relationship that we've got going for the next job. We've got that other job that we're all hoping to be on early next year. Let's try and keep a good relationship between our teams, work well on the next one.
Okay, great. Let's do that. We're agreed. We can shake hands. We can move on. So just comparing that outcome, what happened there? There was, let's say, in this example, circa 5k spent on the expert in terms of payment of their fees, which we agreed to share between us. The senior reps can use any process under the contract as long as they agree to that mutually. Net result is, there's a payment to the contractor, but it's less than the client was originally thinking they were going to have to pay as to what the contractor asked for. And also, there is a recovery for the contractor. It's going to go a long way to covering their costs. Not exactly what either party wanted, as we've seen, but we do have a resolution.
I think one thing to add on here as well, in the cost that it's got of the dispute resolution process going this way, is that you do have to also bear in mind that these senior reps, we've spent quite a lot of time, you and me here, arguing it through, appointing an expert. And that is something that you have to make sure that those senior reps, first of all, that they're available and able to spend that time. It's a 3-week limit that they have to do it, which is sensible to make sure it's resolved before anybody loses their patience. And they have all sorts of methods. They can go to mediation, conciliation, they can do what they like as long as it's agreed, as you say. But there is an investment of time in that, and you need to have the right people. I think there's no limit on the number of people that you can put, or the people that you do put as your senior reps in the contract data, and that will change through a project sometimes. but make sure when you're doing that, filling in those names and thinking about that you choose people that are likely to have the seniority to deal with it and the experience, but also will have the time and the energy and the ability to invest their time in that when it comes to it.
So I think lessons learnt from that revised scenario, sharing problems and not hiding them led to a more positive outcome. Definitely building trust. The impact of the events was reduced as a result of that dialogue that was generated by the early warnings. And the parties resolved the issue themselves. Relationships were maintained. And I think that's a longer term benefit to that, as they're even talking about a new project in the new year.
Okay, so that was sort of two ways of resolving the same issues. One was the more traditional approach, which you could see the problems involved in that. People not sharing their issues, leading to a formal dispute, lots of costs being incurred. The result actually being very similar to what was negotiated the second time round, but with a huge amount of savings and a lot better relationships being maintained throughout. I'm going to open it to the floor for questions in a moment. I can see there are some comments and questions coming through already. But before I do, would any of the panelists like to add anything further before we open it to the floor? Okay, I'll take that as a no, and just look then some of the questions, some of the issues. If you do have questions, please do tap them into the chat function, or else raise your hands using the electronic button to do so, and we can pick up any questions. Did notice there's one comment around the use of a dispute avoidance board, which is something that is now an option in the NEC for ECC. I don't know anybody on the panel would like to comment on the use of dispute boards and whether they think they're good, bad, or indifferent. Julie?
Hi, yeah. We've, as some of the people attending, I hope, the NEC conference where we had the DRBF talk and panel discussion. I am the UK representative for the DRBF, so I'm glad that someone asked this question. I'll try not to spend the next half hour talking about it, but if you want to talk about it, please do contact me or the DRBF. But yes, absolutely, dispute boards, brilliant. The way forward for lots of opportunities, lots of dispute resolution and conflict avoidance more than dispute resolution. But there is, the reason you have the W2 is because of the Construction Act and the right to adjudication. So there's a potential conflict with, if a party wants to go to adjudication, you have to let them. The use of dispute boards is very good to deal with avoiding disputes, asking questions and being used instead of just waiting till the dispute happens, because they have that experience. Unlike a senior rep who is not on site, they're a panel of people that are involved in the project and come regularly to site. So it's a basket full of dispute resolution methods and tools. You've got the early warning meetings. You start off with that, the amicable discussion, trying to get it resolved. If there are issues, you can put them to a dispute board if you've got one on a standing dispute board. But it's an alternative, and not every project will have it. But it's something that you definitely should keep in mind. And I think it was it recorded, the NEC panel? I think it was recorded, so I don't know if
yeah, it was recorded. It's on our YouTube channel if anyone wants to see.
So you can, Cheryl will direct you to it if you need to have a look at that. It was a good session.
Okay, any other members of the panel would like to comment on the use of dispute avoidance boards?
Yeah, I recently, well, 2019 now, it seems like it was only recently, but worked on the Pan American Games in Lima, where we use the NEC contract for the first time in country. So it was all very new, and we had a dispute avoidance board set up. And introducing that style of contract in a country where it's usually a highly litigious environment with any sort of particularly public sector works, was a very massive step change. So, you know, when we started on the project, there was a whole floor of lawyers that then sort of became part of this. Some of them did become part of the dispute avoidance board and the process and the actions that came out of it. But I think, as you say, it just helped so much with that conflict avoidance. So things that could have otherwise spiraled out of control, we were able to sort of manage at that level, particularly with a client that was getting used to using this different form of contract for the first time. So I found it really, really helpful. I think we all came away from it having had a very positive experience with it.
Okay, thank you. Just picking up on a couple of questions that have come through on the sort of more practical side. In terms of the senior representatives, the idea is there is a space for the names of the senior representatives of the clients and the contractor to be included in contract data part 1 and part 2 respectively. The template contract data has room for 2 senior representatives to be named. Really, the idea is to make sure you balance out equal numbers on either side. You could have a single person from either side name. You could have a couple of people. Obviously means that if one isn't available, maybe the other can step in. And there's also, in the amendments that have been made from the original publication, the ability to replace those senior representatives. So that can happen at any time. And then in terms of the process, the parties are able to, or the senior representatives, sorry, are able to choose the process they want, and they can use any procedure, have as many meetings as they think are necessary to get the issue resolved. So it is intended to be inherently flexible, but with a 3-week window to try to focus the minds to get decisions made before we then have to possibly go further to a adjudication if you're under W2, where you can't, as Judy's already said, exclude the right to adjudicate at any time. If you're not in the UK or not governed by the Housing Grants Construction and Regeneration Act, you could select W1, where the senior reps is a mandatory step in the process. Or again, you could look to dispute avoidance boards. Okay. There's a couple of comments there around how does the subcontractor sort of benefit from that process, or how do things flow to them? Matthew, you give a view on that?
Yeah, well, I think actually the subcontractor was a big benefactor from the second scenario, the amicable resolution, because they themselves got their compensation event claim resolved quicker and got paid quicker in terms of their monthly assessment. So they would have been in a much worse position under scenario 1 with a long drawn out dispute, where the contractor was unable really to conclude the compensation event satisfactorily for the subcontractor until they knew where their position was under the main contract, rightly or wrongly. That was the badly behaved scenario. But in, certainly in the amicable resolution scenario, the subcontractor was given a back-to-back compensation event with the outcome of the main contract negotiation. Okay,
thank you for that. Another question around the fact that in NEC3, we don't have that senior reps process. And the question is, is there anything stopping a similar process being introduced there, or other parties agreeing to it? Anyone from the panel like to pick up on that and give a view? Yeah, Julie.
Hi. Yeah, no, I think you can, I think in any contract, dispute resolution is, or dispute avoidance, if even better, conflict avoidance is by agreement. And whatever you put into your contract, if the parties aren't willing or interested in trying to negotiate a settlement of an issue or trying to resolve it, then it's not going to happen. It may be that you get penalised later down the line if you take things to court and you haven't tried, but what we're looking at here is trying to just get those issues resolved and get on with the job and get it done with as little delay and as little overcost as possible. So I think you can always put people in, you can always bring in those ideas. I feel very much that it's important at the beginning, when you're drafting up a contract, most of the problems I see as a solicitor is where people have just said, well, that's fine, we all know this contract, let's just get on with it, we're all friends, come on, it's late, we need to get started, and not consider the contract itself. And that is very important, the question raised, to look at what you've got of dispute avoidance, because nobody's thinking about disputes and conflicts at the beginning of a project. So always do that, always look through that contract and assess risk and work out where the risk lies for everybody. Because if there's an issue arises and everybody knows where that responsibility lies, then no one's going to take it to adjudication or court, because it will just become clear. It's never that black and white, clearly, but knowing where your risk is, ensuring for that risk if you can, making sure you know that it's yours, that avoids disputes in itself. And having people like senior reps in there named is one of the things you can do in most contracts, and you can, even if it's not there in the format, you can put that in.
Mark, from a Yorkshire Water perspective, obviously I know there's, you've had different options within your contracts historically for trying to resolve disputes in a more amicable way.
Yeah, that's right. Sorry, I was a bit slow off mute a second ago. But yeah, there's, from our perspective, we use NEC4 now, and we do utilise the senior managers, senior representatives. But we had a very similar process in previous investment cycles as well when we used NEC3. So, you can write a very simple escalation process, which is what we did, which still doesn't conflict with that right to adjudication. So I think as long as you preserve that, and I think Julie will advise better on that, but as long as you're not interfering with those rights, the contract is the bare minimum in terms of what you should do to try to resolve a dispute. You can write other processes in, or you can have other informal processes by agreement, and we've seen all of those work in the past.
Okay, thank you. Couple of questions come in around what happens if you fail to notify an early warning. There can be consequences for the party or for the contractor if they fail to notify an early warning under their contract with the client. Similarly, there can be issues if the subcontractor fails to notify early warnings in their contract with the contractor. Here, the subcontractor was under the engineering and construction subcontract, so they would actually have the obligation to notify early warnings under that contract. Whether the contractor then chose to pass them on will be almost for the contractor to decide, but I think it would be a foolish contractor who didn't share those. But the idea is there is a need to notify under both the contract, subcontract, main contract, and consequences for a failure to do so. Interesting questions coming here, and maybe Nisha, if you want to have a think about this, and then also Matthew. Question or comments raised. It's quite common that contractors produce programs that show delay being recovered, maybe over optimistic about recovering delays they're already actually suffering. Can the project manager actually refuse to accept that, or do they have to believe the contractor's optimistic expectations? So Nisha, do you want to have a go first on that one?
Well, I guess it's, it is up to the project manager to make their assessment, really, isn't it? So it's up to them to make sure they've got all of the information and have reviewed it and assessed it in with as much detail as possible, so that they can understand whether that, being a project manager, you'd assume that they would be able to have a good level of knowledge as to whether that was optimistic or not. But I think that's where the discussions and working together and really trying to work through those issues really helps. So so that understanding is based on as much fact, as much objectivity, and as much information as possible, rather than obviously just dismissing it out of hand.
I'd say the same thing. Actually, problem solving is important, and any client would want the contractor to be doing their best to meet dates and not just accept slippage. But it boils down to whether the program is realistic. And I think the point that Nisha made, the real benefits of having a trusting relationship are that the parties can solve these sort of things. They can come to a meeting of minds as to what's realistic and what's not, and everyone benefits. You know, if contractor, client and project manager fall out, it's very, very difficult to get anything done, and everybody needs each other's help to make a job successful. And there's just a good example there, really, in that difficult program discussion that might arise from time to time.
Yeah, ultimately it becomes a judgment, but hopefully that conversation, understanding, you know, interrogating in a hopefully a constructive way as to the program that's been submitted, whether it's realistic, is going to be part of those conversations. I think we all have to understand that programs are estimates. You know, this is not an exact science. Things will go differently to what was expected, but at the same time, there needs to be, you know, ultimately the project manager has to make that decision on the information they have available. Okay, there's been a few questions or comments raised about the designer, and that the designer is possibly not been too involved in this scenario, even though potentially they were part of the problem in that we had a design issue. And so we didn't explore that in this particular scenario. I don't know if anyone's got any sort of thoughts or views around that. I think if I may just start off by saying that, you know, the designer, yeah, they'll have a contract, as we've seen, a professional services contract with the client. That will create a need for them to undertake certain activities and to deliver work to a certain standard, which is a level of reasonable skill and care, as opposed to fitness for purpose. So there may well be a discussion between the client and the designer. What was the error? Why wasn't it spotted? Why wasn't it identified earlier, etc.? But then you may have to get into a conversation over whether it was a failure to use reasonable skill and care. Consultant is going to be sort of liable for the consequences, or whether it was just, you know, something that was maybe a really high-tech design, state-of-the-art, and okay, there was an error, a problem discovered, but this couldn't have been necessarily spotted in advance due to the difficulties. But I'll open it to the rest of the panel to share any further thoughts around that.
I think, excuse me, I think that we discussed this previously, but it's having the design in advance. I saw there was a question popped up about why didn't they check the design, which was a very valid point, I thought. We discussed this when we were preparing for this this workshop as well. But as we all know, you don't always get the design before, you know, or in good enough time to do that. But that is part of the deal, I think, is to make sure that the design is ready and people have had an opportunity to check it, because you can't really blame a subcontractor who's had been thrown onto site to try and keep the programme, and he's only received the design without adequate time for him to actually go through it in the detail he'd perhaps like to. So, but that, as we said, that's, as you said, that's another, it's probably a topic for a whole webinar to discuss design issues. But it's something, they have got that contract, and that's the separate contractual link that you would need to follow up on, and that's where it starts getting complex if you then find that people pursue the designer after the event, perhaps for the issues or the costs of what has been decided by the parties, or by an adjudicator, or by an arbitration.
Okay, thank you for that. Just looking at, we're almost out of time in terms of the hour time slot we had. So for those who have to leave, then we appreciate your attendance today. I think it's already put into the chat that copies of the slides will be issued out. The session has been recorded and will be made available. I think as panelists, we can stay on for a little bit longer if there are any more sort of pertinent questions anyone would like to ask. If not, any questions that do come in that we haven't answered, we can provide a response to and share that through the NEC website. Okay, I'm not picking out any sort of other burning questions that have come through on the list of questions. So maybe a final chance if you do have any questions to raise before we close out. Okay, I'll just turn to the panelists. Is there anything you'd like to add before we close out from anybody? Okay. In that case, I think we'll say thank you to the panelists and for your contributions today. Thank you for attending, and we will circulate the slides through the normal channels after the event. So thank you and have a good rest of the day.
Thanks, everyone.
Thanks.
Thank you. Bye-bye.